So welcome to those attending in person and to our many colleagues and friends that are attending via WebEx. The crowd in person gets smaller and smaller each year, and we get more and more online. So at some point we may just make this a full-fledged online event, but or go to a smaller venue here in the building so you're not all lost in the sea of Strom Auditorium chairs. But I'm glad that you took the time to come, especially on a rainy Friday, and we're always happy to see our Georgia Northern judges and friends. Those that are participating via the WebEx, if you have any technical problems, you can send a message via the chat line on the screen, and if you have questions, you can also send them, and they will be relayed to me. So we will begin, as I always like to kind of give a little statistical report, and these come from the Administrative Office of the U.S. Courts, and it's for the 12-month period ending September 30, 2019. Georgia Northern remains the third busiest court in the country, and that's been the case for quite a few number of years now. As I've said, I think last time and probably the year before that, it's that everyone's declining, but we're staying in the decline. Last year we ended up probably about 2.5% down from the prior year, and that's kind of where we are now as well. For the period ending September 30, we had just under 30,000 cases filed, and just for a frame of reference, the number 1 and 2 are listed here, courts. One is Northern District of Illinois, which is the Chicago area, and they had almost 40,000 cases filed, and Central District of California was just under 38,000. And it's been 1, 2, and 3 like that for quite a few years. Just a little reminder that our highest filing year in Georgia Northern was 2010, and we had almost 55,000 cases. So y'all need to get busy. Get busy. Times are quite different. Lots of things are different. So we appreciate that you're helping tens of thousands of debtors here in our district. For the 1,000 per 1,000 filings, per capita filings, we have in Georgia Northern 4.24 filings, which is 8th highest in the country. That compares to the highest, which is Tennessee Western, Memphis area, and they have 8.4 filings per 1,000. So, and they have been in that position for a long time as well. And for pro se filings, even though it may seem like more, we're the 21st ranked court in the country in terms of pro se filings, and 9.2% of all of our filings in the district are pro se. And that's pretty standard. We run that month to month. 8 to about 10.5% of our filings are pro se. For the budget, just so you know, we are operating under a continuing resolution, which expires at midnight on the 21st of November. There is talk that there will be another CR. Washington's busy with lots of other things right now, apparently, and not funding the government fully. So the talk is that there will be another CR that would continue operations through December the 20th, but I have seen nothing substantive. That's just been some chatter that has gone on through some media outlets and through the Speaker's office and through Mitch McConnell's office, that they're working on that. So we'll see. I hope that we do have another CR. As you know, there was a partial government shutdown earlier this year. But as a reminder, the federal judiciary has funding separate and apart, some limited amount of funding separate and apart from appropriated funds that we get through Congress, and that's mainly filing fee income. So we maintain operations, and we can do that for several weeks before we actually go into what we call shutdown mode. So even in this last shutdown earlier this year, we never changed our operations. We didn't have to, because we continued to receive funding to sustain full operations, and that's all court units of all kinds in the federal judiciary. So if there is no continuing resolution or budget, which there won't be, by September 21st, then we would continue to work. So we're open for business. And that will be the case for the foreseeable future. So last year at this time, we spent a good part of this meeting talking about new general orders about service and a whole host of other things. It's been a little quieter this year, except that we do have new amended local rules that took effect September the 1st. It's a long process. You know, we've been talking about these local rules for many years, if you've been coming to these meetings, but we finally, with Judge Hagenau's stewardship, got across the finish line. So you have to go through the district court for approval, then it goes up to the Circuit Council, 11th Circuit Council, and they were all approved and effective September the 1st. So we've had lots of notices throughout that period of time advising about the changes. We had a comment period that ran from April 11th through May the 10th. Received very few comments actually about the changes, and maybe that's because a good number of the changes really kind of codified procedures that had developed over time since the last substantive revision of the local rules. So there weren't that many comments, but we addressed those. It has to go back up to the district with our responses, and it's a process. But in any event, they've been in place now since September the 1st, as indicated on the slide. And by the way, this PowerPoint will be placed on the website along with a recording of this meeting in the next couple days. So as I indicated, some of the rules went on to explain processes that had developed, and that includes, for example, the process by which the court may dismiss a case for failing to pay the filing fee in installments. That's BLR 1006-2, or failing to file certain required documents, and that's BLR 1017-1. And then other rules were amended or clarified, and these are just for example, the ex parte relief motion for lack of insurance with automobiles, appearance conflicts, how to withdraw from a case, those were tweaked or amended, and those were all spelled out to some degree in a public announcement about the local rules. They are posted on our website under the tab Local Rules and General Orders. And if you want to see a blackline version of the rules, what actually changed, those were sent out at the time the rules were effective. If you look at under news and announcements on the August 21st, 2019 announcement, you have the current version now that are effective, as well as the black line. So you can see what changes. There were a lot of, I'm going to say, non-substantive in that they just sort of cleaned up language, made things consistent, got rid of things that were outdated processes. But there were certainly changes that you need to be aware of. So speaking of news and announcements, if you haven't, and you all should be receiving all of the news of the court through the Gov delivery system, and that we started 2 years ago?
Yeah,
maybe about 2 years ago. But if you haven't, or for some reason want to add another address or other folks in your office, in the PowerPoint that will be a live link to how you do it. It's super easy. It's on our website, and you go to it's the bottom of the first page or something, and you go to email updates, and so you will then receive any Gov delivery announcement that the court sends out. It could be for weather issues. It could be for new local rules. It could be for CMECF is unavailable. I mean, we use it for a host of communications that we used to in the old days send out through just email groups, and it just wasn't effective anymore. So if you don't receive Gov delivery, I urge you to sign up for it, and then I urge you to read them. Because I think that's what we find a lot of time is people get them and they delete them without actually looking at them, and we know that because then we get calls and emails saying, why did that happen? We didn't know, but you in fact did know. You just didn't read it. So I encourage you to do that, to get them and read them. So here's kind of a synopsis of some of the, I'm going to say more substantive messages that were delivered through this system that would affect your practice or give you some new tools. One is, and the date next to it is the date of the news and announcements. So you can always go to the archives. If you're looking at our website on the right-hand side, news and announcements, they're all listed, and there's an archive. So you can go back, I forget how many years, but you can just click on it and see exactly what was sent. But these are the dates of those announcements. So the first one is the updated calendar tool. So I'm just curious, how many people use the calendar tool to check hearings? Oh, you should all be using it. It's good information, and it's easy to use. So go on the website, look at the calendar tool. We had some complaints that the tool didn't include meeting of creditors information, so now that was modified to include meeting of creditor information. So I just think it's a good place to go. It's not, of course, official record, and we know sometimes things may be reset that don't appear on a calendar yet because they've been continued or something like that. But for the most part, you're going to be able to manage, I think, your calendars based on that calendar. So we did that. We're also looking at a really robust new calendar program that was developed by another court that is pretty great. So we're testing it, and I think maybe right after the first of the year we'll be able to announce a new, really swanky, fancy calendar tool that you might like even better. So you can be on the lookout for that. Hold on 1 second, y'all. Okay. And then on August the 7th, we sent out a public announcement regarding the court website. And I think it was last year's meeting that somebody said, when are you going to make your website mobile friendly? So you know what we did? We made the website mobile friendly. And then we told you about it. So it's easy to use and adaptable for your phones, iPads, and mobile devices. And I hope that has been helpful. I know it's been helpful to me. Then on August the 15th, we sent out a public announcement regarding request for order terminating employer deduction order. And this kind of keys into some situations, and it happened way back in the dark ages when I was a 13 trustee, where you couldn't get the employer to stop deducting money, and it just messed up the debtor, and it just messed up your processes and closing out cases and things like that. So we developed an event, it's a docket-only event, that can be used in certain circumstances to terminate an EDO, and those circumstances are if the debtor's case has been dismissed or converted, and the attorney can use this. The attorney can use this event, and the 13 trustee can use the event once they file their notice of plan completion. They can do it. So it's not a motion and order. It's a docket-only event that you go in and request this termination of the employer deduction order. So it's a really, I think people who have used it really find it helpful and efficient. I'm curious, has anybody used it in this room? And do you love it? We love it. We love it down here. So, yeah, these are, for those on the phone, these are two of the 13 trustees, Nancy Whaley and Melissa Davey, are here, and they use this when they're doing their notice of plan completion. They go ahead and terminate the EDO, and that helps them in their closing process, and certainly helps your client. If they finish paying, there's no need for money to keep coming out, and then you're having to return it. So, again, the announcement of August the 15th will give you the details about how to use it. It's pretty simple, and hopefully will be helpful. Then on October the 8th, we sent out an announcement about an unclaimed funds locator tool. And just a little bit of background, there's been a lot of talk on the national court level about all the money that courts are holding in unclaimed funds, not to be confused with registry. This is unclaimed funds. So just as an example, in Georgia Northern, we have over $10 million of unclaimed funds dating back to the mid-'70s. And it's sitting there in the Treasury because by law, it can't go anywhere else. So, you know who, the biggest problem I have with that, well, two, I shouldn't say this. There are lots of problems with it. One is that people who are entitled to the funds don't get them. And that's, of course, the whole point of what we do. The second problem is I'm liable for that. As the clerk of the court, I'm liable for accounting for $10+ million in unclaimed funds that sits in the Treasury. And so multiply that by court units all over, there's probably, by now, $275 million of funds that can be attributed to bankruptcy cases that sits in the Treasury and by law cannot go anywhere else. So the committee on the bankruptcy system started looking at this, the Judicial Conference Committee of the bankruptcy system in Washington started looking at this, like how can we make this easier, streamline the process, help get the funds out to the right people. Short of statutory changes, which they also want to work on, that says after, say, 5 years, that money can escheat and go into the general, it can't go back to the court, unfortunately, or to the clerk who's responsible for it. But it can go back to General Treasury. It just doesn't sit. It can do something with it. And that takes, of course, years. So in order to do something, they came up with a couple of approaches to identifying the money and letting people know where it is. So as one of about 70 courts that is on a financial system called JFinCIS, we participate now in this unclaimed funds locator, which is on our website front page. You can click on unclaimed funds, it takes you right to it. And there's a drop-down menu of all the courts around the country that participate. Like I say, now it's over 70 out of 90 bankruptcy courts. And you can literally type in Ford Motor Credit, and all related names of Ford Motor Credit Company, Ford Motor Inc., or whatever would come up. And you can limit its search by district, or get a global, and you can see case information, where that case is, and how much money it is. So that was phase one of it. So you don't have to call individual courts and say, well, how do you maintain your unclaimed funds? And can you tell me if I have any? So now we're in this central system. The other part of it is, how do we get it out? And that really was the challenge, to try to get courts to agree to use a certain set of standard forms for motions or petitions, they call it, petitions for unclaimed funds, and then orders. So we are, Georgia Northern will, beginning December 1, start using the standard, it's a director's form, the director of the administrative office. They're called director's forms. They're not official forms. They're recommended forms, director forms, and there's lots of them out there. So we're going to use it, and hopefully a lot of courts will use it. So if you are a creditor that handles clients that have multiple districts, litigation, or interest, you don't have to go to each website of each court and say, oh, I have to do it this way. Some courts you had to file a motion and have a hearing and go through all that. In our court, you don't have to do that, but there are certain requirements for documentation, affidavits, things like that. So starting December 1st, we are going to be using the director's forms for petitions requesting unclaimed funds. There's a standard order authorizing it and an order denying it. So we'll put those out there so you can look at it. I haven't asked the judges this, but I believe they would agree with me that if there are things in process, we're not going to kick them out. We'll finish the ones that are out there. But we will encourage, and at some point probably require, that everyone use the new forms after December the 1st. So I hope that will make it easier for some of y'all. And again, if you represent debtors, you might want to just try the unclaimed funds and see if you're in a prior case, perhaps your client had funds that were returned for some reason, and you can see it right there what case it is, and check the docket on that. So, any questions on that? Okay. And again, on December the 8th, we'll put out through our notification system a message from the Bench and Bar Committee. And this, I'm just going to read to you what the notice said, because we haven't received too much action from this, but I want you to know, and I think it's important for you to know, that the judges really are interested in this information. So I encourage you to think about it and discuss it and maybe submit a response to this. But the announcement says, as new local rules for the United States Bankruptcy Court, Northern District of Georgia, became effective on September the 1st, 2019, the court continues to examine whether there are differences in chambers' processes under all chapters of the code that the bar would like the court to evaluate. If you have a specific example of a non-substantive procedure adopted by one or more chambers that differs from the other chambers, you may provide feedback to the Bench and Bar Committee. And there's our link to our address on that. Again, this is, when you get the PowerPoint, this is all linked. But there is a Bench and Bar at ganb.uscourts.gov email address that only comes to me. I'm the only one who sees it. And then the announcement goes on to say, please include your view on the benefits or drawbacks of the procedure. So the court really is interested in hearing from the bar about these non-substantive procedures that might differ from chambers to chambers. Finally, the message says the Bench and Bar Committee, in this case just me, even though there is a working committee, will summarize the suggestions for the court's review. And the comments will remain anonymous to the judges. And that was made really clear to me. The judges don't want to know who made the comments. I am not permitted to tell them. I just have to say, here is the comment or comments, and we ask you to review them. So I encourage you to take that opportunity, because a lot of courts don't really go out seeking comment from the bar, and ours is really committed to that, our bench, so I encourage you to do that. And then the last one I was going to mention, the announcement was on October the 9th, and that was the public notice regarding distribution lists on orders and requirements of the Bankruptcy Local Rule 9013-2. And that announcement, what we saw was that after September 1st, local rules went into effect, which does authorize electronic service for ECF participants for document pleadings and some documents, that we were seeing orders with distribution lists that didn't have addresses. They would just have an email address. So serve these parties, and it would just say, bobsmith@gmail.com. That doesn't comply with Bankruptcy Local Rule 9013-2, preparation of proposed orders. That rule didn't change when the rules were amended. So the rule, as it stands, reads, quote, if the bankruptcy clerk is to serve the order must be accompanied by a distribution list containing the names and addresses of the attorneys and parties to be served. If the proposed order seeks to have the bankruptcy court serve all parties in the case, the distribution list shall state all parties on the mailing matrix, which is an option in CMECF. All parties on the mailing matrix. That is a living, breathing matrix. So trustees on that, creditors that are added get added to that, notice of appearances get added to that. That is the comprehensive matrix for a particular case. So that is what you should be saying if you are intending to serve all parties. I would ask you in the big picture to consider carefully who needs to be served with your motions and orders. It might be easier for you to just serve everyone, but if they don't need it, it's like I say, it's a burden to the court because we don't sit there and type envelopes anymore, but it's a cost to the system if we have to serve all parties, and it really is not necessary. So it is incumbent on you to determine who needs this motion, who needs this order, and make sure that the documents and the distribution list show that. So when this announcement went out, it stated that effective immediately, and this, like I said, this went out on October the 9th, any proposed order submitted with a distribution list that did not comply with local rules would be returned. And I haven't been told that we have this as a continuing issue, so I'm looking at my folks if they're going to tell me otherwise, but we wanted to make folks aware of it. So any questions about any of those announcements that went out? Okay. So a couple of other things about, I'm going to say news announcements or reminders. You may have noticed that beginning in early September, actually September the 4th to be specific, prior case filing information started appearing on the docket. Everybody seen that? So a few people, not many, but asked about it. Where did this come from and why is it showing on the case now? And that's actually in a docket entry at the beginning of the docket after a volunteer petition and maybe one or two other traditional entries. That is an event that was actually released by CMECF back in 2012. And at the time, we didn't turn it on. We didn't flip the switch. And after some discussions about issues, the court decided they wanted that on the docket. So we flipped the switch. So starting September the 4th, you see that information. It is linked in through National PACER. So it not only gives case information, prior filings for Georgia Northern, it also reaches out if there are cases filed in other districts in the country. It lists the cases regardless of the year filed or the disposition of the case. So it's not just discharge cases or it's not just dismissed cases, it's all cases. So I would say two things. One is that all of that information with regard to Georgia Northern cases has always been there under the associated case tab. It just wasn't on the docket. So that's not new information. That was always there. You just had to go to a different box and click it. What's new is that it's pulling in information from other districts in the country. So I just wanted you to be aware of that, and if you haven't noticed it for some reason, that is appearing in docket entries. kind of related to it in a long way that you don't really are not interested in. We started looking at how many cases in Chapter 13 were getting closed without a discharge. And I decided that I wanted to kind of tackle that because I just, maybe it's my historical love of Chapter 13. If somebody makes it to the end of a case, I'd like for them to get a discharge. You know, they've worked their way to the end. So now, when the situation comes up where our staff is looking at a case to close, if the 1328 statement or the financial management certificate has not been filed, but otherwise the case can be closed, they refer it for review. We're just not proceeding to a show cause hearing to close without a discharge. So since we instituted this earlier in the year, over 550 cases have been referred, and we've reviewed them. And I have emailed attorneys, and I have sent letters to pro se debtors, and sent them forms, sent them the 1328 form, and told them where to go get their financial management. And I'm really happy to report that out of that over 560 now, only 50 cases have been closed without a discharge. All the rest have ended up with a discharge. And it is work for the staff, but I think it's important because we want people to get what they came here for, and that's a discharge. So now we're talking about how can we do this in Chapter 7. A little bit different because there's so much faster. And we have an automated closing process now, a computer program, that if all these boxes are checked, the case is going to get closed. If, for example, the financial management certificate is missing, it kind of spits out an exception report. So we're kind of evaluating how many of those are there, and can we manage doing the same kind of outreach to debtors and attorneys to try to get the sevens in the same situation. So that's on the horizon. But people, when they first started getting these emails, I send the emails myself. And people would respond like, "What are you doing? Why am I hearing from you?" Or they felt like they had to say thank you so much every time. And I said, you don't have to respond. This is really, it's informational. We've got, give you a couple weeks, try to get it done. If not, we're going to go through the same process that we always have had, which is refer it to chambers, set it down for show cause. There's still an opportunity before the case is closed without discharge, but we're trying to keep it from getting to that point. So I hope that we can do this in Chapter 7, because I would really like to see debtors leave the court with what they came for. So that's all by way of FYI, things that we're doing in the clerk's office. The next thing I wanted to mention was to really please flatten your documents before you file them. So who has no idea what I'm talking about? Thank you for admitting that. I didn't know either before we went to the new the not so new Chapter 13 plan now with fillable fields and all that, where you have to flatten that document, or we tell you we're not going to serve it. So people are doing that now. You're flattening your Chapter 13 plans. That keeps the information locked, basically. So what we started seeing, however, in lots of other kind of documents, the documents were not being flattened. And we found it because, if I'm remembering the history, that a judge could see something on the desktop that they couldn't see on a laptop, or vice versa. It was that kind of thing. So we started looking into why does this look different? And it's because the document was filed without being flattened or locked. So we started looking at this, and our IT guys did a great program that actually scans every document filed daily and spits out a report that says these documents were not flattened. And what we find, a lot of them are where if you're using a document that you say over and over, certificate of service or something, and you change the date over and over, if you don't flatten it, I can go in there, click over the date, take the date out, change your document. I can change your address. You can change account numbers. You can change things that you don't intend to be changed because they're not flattened. And it's super easy to flatten a document. You just print it to PDF before you file it. Don't save it to PDF. I'm looking at my IT director right here. You print it to PDF. And that locks the document, and then you file it, and you don't have to worry about sensitive information being changed. So we ran this first report, and not surprisingly, there were a whole lot of documents that were not flattened. So I picked the largest offender and reached out to them. And I am so happy to say for the last 3 days, they've had 0 unflattened documents. And that came down from like 200 and something documents in a day to 0. So we're going to be looking at other minor offenders. And you might get an email or a call from myself or Craig Raber, our Chief Deputy for IT, saying, hey, you had 33 documents yesterday that could be changed because you didn't flatten them. So it's a real simple process. I just ask you to be real careful about that because it's really for your client's benefit more than anyone. Yes?
So, other than the plan, we're supposed to flatten every document?
Yeah, the question was, other than the Chapter 13 plan, are you supposed to flatten every document? I would say yes. It's easy to do. It's just how you're saving it before you attach it as a PDF to your entry.
It's very easy to do. I just didn't know where you're supposed to be.
Yep, thank you. Okay. And then this is coming, requesting from the staff too, is for you to be sure to keep your address and email current for your CMECF accounts. You may or may not be surprised at how many times we start getting bounce back emails that we investigate and we find out, oh, I've changed firms, or oh, we changed our email, addresses, and that affects your ability to get timely NEFs, and it adds, it adds some work for the staff to investigate change and make sure everything gets updated. So all you have to do, and again, it's in the PowerPoint, and that is hyperlink when you actually get your PowerPoint download. That's the email address. You just send what you need to update to the help desk, ECF help desk, and they will take care of it promptly for you. And then my last thing, and I think I say this every time, is that on the website we have the online procedures manual, and we have an internal one that we did, and we have an external one for y'all, and it is so helpful. If you click on anything you're trying to file, any event in the system, it will take you step by step by step what you need to do. It'll link to local rules, it'll link to federal rules, it'll tell you if you have any kind of question about the kind of event you need to use. There's an easy search feature and it'll give you the options. So we continue to maintain that. Obviously we update it constantly. Anytime there's a new event or anytime there's a change in rules or procedures, we update it. We use it, everyone uses it daily within the court. We've gone away from any paper kind of manual. It's all online so that it's current all the time. But we did create this external one, and we just encourage you to use it, refer to it. And if you ever have questions about it, if you find a link on there that doesn't work anymore, because these are, programs that live and breathe, let us know. It's just we've invested a lot of time in it, and we hope that it will be a helpful thing for y'all. And one more thing about the Bench and Bar Committee, I talked about it earlier. On our website, we have a tab that is the Bench and Bar Committee. It lists the membership of the Bench and Bar. It has our address. If you want to send it, it's again what's showing here. If you have comments or questions. The Bench and Bar Committee, which is chaired by Cece Schnapp, who is Chief Judge Hagenau's career law clerk, they have done a great job over the last couple of years of doing lunch and learn programs. And I know I've seen a lot of y'all there, and we do them by WebEx now too. And we have a lot of participants via WebEx. And these are just some examples of, over the last 18 months, the lunch and learn programs that have been done. So and they're all on the website under the tab, Bench and Bar. The audio's there, the materials are there. I think they're very helpful and interesting, and not too long. They're short, less than an hour. The committee is interested in suggestions for 2020 lunch and learn programs. So if you think of something you'd like to see of interest to you, if you just send an email to the Bench and Bar email, we'll pass it on to the committee, who meets several times a year, and see if they can put together a lunch and learn on that topic for you. So, unless there's any questions about any of that, we'll move on to the rules changes for December 1. It's kind of a light year this year, which is good. Sorry, I'm trying to get my papers up to date here. So I'll talk about the ones that there are a few more than this, but these are the ones that I think are most significant for our purposes. And the first one is an amendment to Bankruptcy Rule 4001, which is specifically dealing with procedures for obtaining post-petition credit. And it was amended to add 4001 C4 in applicability in a Chapter 13 case. And it just simply says this subsection C, which talks about how to obtain post-petition credit, does not apply in Chapter 13 cases. And this is really because, as you know, most Chapter 13 trustees, and certainly in our district, have internal processes for debtors obtaining credit in 13 that were different or maybe easier than what was contained in the rules. So there were no comments to this, public comments to this amendment when it was sent out for review, and so that is changing, adding section 4001 C4. 6007, abandonment or disposition of property. This was amended to correct an inconsistency in who had to be served with a notice of an abandonment. Rule 6007A identifies the parties that have to be served if the abandonment is by the trustee. 6007B was silent as to who had to be served if the abandonment was by a party in interest. So 6007B was amended to specify the parties to be served with a motion to compel abandonment and notice of the motion, and to establish an objection deadline. So it just cleared up that conflict in the sections. Rule 9036, notice of electronic transmission. This rule was amended to permit electronic notice on registered CMECF users who have appeared in a case, and with the consent of parties, allow for electronic service by means other than the CMECF system. So I put in the PowerPoint the specific language. I'm not going to read that, but the specific language of the change. And of course, electronic service like this, under this section, does not apply to situations where Rule 7004 service is needed. It's required. So this rule was in response to proposed amendments to Rules 2002 9036 and Official Form 410, which would have allowed a creditor or equity interest holder to receive notice by email if they checked a box on the proof of claim form. Now that is not changing. That is not going into effect. But there was discussion and comment and all kinds of discussion about that. And as I understand it, the comments that they did receive when that went out were pretty positive. Like, people wanted that, but they were afraid that they could not get CMECF configured in time to make it happen by December the 1st. So this rule is sort of a stopgap, I guess. I don't know if the other rules are going to continue to be considered. I can't remember if they're in the December 1, 2020 rules that are out for comment. I just can't remember at this minute. But in any event, this is an important rule to know, and it conforms to what we're doing with our new local rules in terms of electronic service. And Rule 9037 is privacy protection for filings made with the bankruptcy court. And this adds a subdivision H under the motions to redact previously filed documents. And again, this PowerPoint has the exact language of the change. But it applies to the information under subdivision A of the rule, and that's we call it the big four, Social Security number, account number, birthday, and minor children's names, those four things. So it's more of they're trying to make this more of an automated process because, and again, I think this relates a lot to the way courts were doing this in different places. Sometimes there would be a motion, you'd have to set it for hearing, and so the unredacted information was just out there for a long time. And so if it's important enough to come under the subdivision A, to the big four, they want it to be handled and redacted, or at least away from public view immediately until the court enters an order on whether the redaction can happen. So this goes on to tell you what has to be in the motion. The parties must file a motion to redact the identifying information, attach to the motion the proposed redacted document. This is what I want you to use instead of the one I filed. include in the motion the docket number or proof of claim, whatever that unredacted document is, and they have to serve it. It tells you where you have to serve it. So that's part A of the process. The other part is from the court's end. And so we will be implementing, and we haven't finalized it yet, but some sort of process whereby when the motion is filed, if it applies to those 4 categories, then the entry will be, it'll be locked down immediately until there's an order entered saying either yes to the redaction, or if the court denies it, then you open it up again and the unredacted document is there. So that is not presently what happens. We do it a little differently now, but this rule sort of directs the courts how you have to do it, and they want it immediately. They want it, I think the word is promptly that they use. Yeah, the court must promptly restrict public access to the motion and unredacted document pending its ruling with the court. So that's sort of that's what we hope to do, is that as soon as the motion's filed, it's redacted with the unredacted document pending an entry of the order from the court. So those are really, and like I say, this is kind of a light year for rule changes, but those are, I think, important for you to consider. Before we go on to the director's form, I just wanted to mention that, and you probably already know this, that the Congress enacted a new section of Chapter 11 to deal with small business bankruptcy. It's a Small Business Reorganization Act of 2019 under Chapter 11, and it did not go into effect immediately. The effective date is February the 19th, 2020. And there are, the intent is to make small business Chapter 11s more efficient, less expensive, give it a better chance for success, because a lot of them, a great majority of them, don't succeed in the traditional Chapter 11. There are lots of things that the U.S. trustee is responsible for and are developing, including the selection of trustees, and that's a process that's happening right now. We sent out a notice on their behalf with application to search for these trustees nationwide. So there's more news to come on this, but I just wanted to make you aware that that is out there and it's being developed, and we'll have probably a general order that gets entered addressing some of the things that need to be done in order to effectuate the new statute, and the court will consider those, I would say, soon, since the effective date of this is February, mid-February. Okay, so then on to this is just a follow-up. I already think we talked about this already, the unclaimed funds, and the director's forms, and how we're going to hopefully let people get money out of the court system. So at this point, I'm going to open it up for questions. If any of our participants on the WebEx have a question, if you just use your the chat box, they can relate that to me. Any questions? Anything? Yeah. Nothing? Okay. Yeah. So just a couple of general announcements. I'll ask Nancy Whaley to come on up. She's got a couple of announcements on behalf of the trustees. While she's coming up, let me just run through a couple of these other quick things. We're coming into our potential weather delay season. And just to make sure everybody is on the same page, WSB is our official outlet for news related to the bankruptcy court closing. You should always see specific announcements as to each division, because it may not always be the same. And there will be specific announcements as to bankruptcy court versus district court or any other federal agency. I just want to clarify that if the bankruptcy court could decide to delay or close, but another agency may not, or vice versa. So always default to WSB and our website, and we send out Gov Delivery if our computers are working. And that's the source for official information for what we're doing. Sometimes the U.S. trustee will ask us to include in our announcement, their 341s will be rescheduled. Sometimes they don't. So if we know, it'll be included. If we don't know, you may have to get information from the U.S. trustee.
Question?
Yes.
How can we get a copy of the presentation slides?
Oh, okay, we'll get to that at the end. Thank you. Another real quick thing, construction around the building here was supposed to be done in December. of this year. If you're like me, you come down here every day and there's never anybody working. There's some problems are happening between the city and the contractors. So we were told maybe a month ago that it could take as much as another 6 months, and we've heard nothing since. So all I can say is we'll let you know if we know something. But it's just a mess, and it's apparently going to be a mess for a while. Nancy, you want to come on up?
Good morning, everyone. I'm here on behalf of all 3 Chapter 13 trustees, and Melissa Davey is in the audience passing out flyers to everyone. But we wanted to let you know that all 3 Chapter 13 trustees, we have joined with a company called TFS to allow a new, different payment option for your clients. And it's way more robust than what we currently offer through our ePay systems. And so we would love for you to go visit the TFSBillPay.com's website. They did a presentation last night at MacBag, and MacBag will be sending out the slide presentation from that. But their website has a lot of videos and Q&A that will be helpful to you. They are also willing for any debtor attorney, if you would like to do a webinar with them or just chat with them on the phone, they are willing to do that. But just to let you know, just a few highlights of what your client can now do. One is our current systems have never allowed your client to set up a recurring payment. So they have to go in every month and set up that payment. With the TFS system, they even have it so if your client is Social Security and they get it on a certain day of the month, they can go in and set that day of the month up and have it recurring from here to the end of their case, and the debtor remains in control of that. But there's also a portal for you so that you can see that and you can assist your client in setting that up, unlike our current system where you really can't do that. They can do it on a monthly basis. They can send in their tax refunds that way or any other large payments. So they can do reoccurring and they can do one-time payments. There are some other options out there for an employer. If you have a small employer, they can actually set up an account and make the payments through the ePay system. And I think it's $1.99 for that employer to do that per debtor. But also, if you have a client that's in maybe a sensitive situation or one of those type of employers that is not large enough to really have an employment deduction order, and we all struggle with how we handle those situations, now they have an option where it's almost, the employer doesn't even know that they're making a Chapter 13 plan payment. They just know it's a deduction that could be going to a savings account or somewhere else. It's a private identifying account number. So they would go in just like if they wanted to set up a direct pay for their checking into their savings. It would be similar to that. And we would receive those payments. So there are a lot of great options for it. It also allows you in emergency, well, you can do it at any time. We would highly recommend you only do it in emergency situations. But your clients can go into any place that has a MoneyGram option, so Walmart, CVS. There are thousands of these across the country. So if you have a truck driver that's traveling across the country and he needs to make its plan payment, he can stop in Walmart, go into a MoneyGram, and make the payment through MoneyGram. So I just really encourage you. The other great part about this, which the attorneys heard about last night, is there are a lot of reporting in there for you. So if your client doesn't make a payment, it can show up on a report that you get on a daily basis or a weekly basis or monthly, however you set it up. And you can see all of your clients that did not make a plan payment so that you can reach out to them. They also will nudge your clients and send them an email or a text message and say, hey, we didn't get a payment from you. Is everything okay? Did you forget? Don't forget to make the plan payment. So it's got a lot of great features, and we hope it'll help debtors get on track early in a case. So it's a great feature also to use if you have an employment deduction order, but you know that payment won't come out for a month because the employer has to set it up. Go ahead and have your client make that first payment through the TFS payment system. Then they are in there as a record, and so they can get those prompting emails as well. But you can visit. It's Debbie, and then these are the flyers that we'll be handing out at 341 meeting of creditors and in court, passing them out. But Melissa also handed out some other flyers. We had some extra ones from last night that tells you about MoneyGram and the e-wage and some other information. But I encourage you to visit their website. The other thing I just want to let you know, in my building, The SunTrust building has implemented security measures, which a lot of downtown, buildings throughout the country have done. So you will no longer be able to access my suite without going through security. What we highly encourage you to do is, if you need to come to my office for a Business 341 or anything else, is if you contact us, then we will pre-register you. You will get an email on your phone or wherever, and it will explain to you how to go through the system. You just go to a kiosk at that point. I think you show the barcode and it prints out your security badge. If you're not registered, then you will have to do it on site, and they will contact us, say that you're there. We'll send an email saying, yes, it's approved, and you can access the building. But we highly encourage you to let us know that you're coming so we can pre-register you, even if it's 30 minutes before you're coming or a half an hour or a day before. The same with your clients. If you know your client's coming down to our office, which I think all 3 trustees want to say, anything your client can do at our office, we can do with them through email, telephone. There's really no need for them to come to the office and pay for parking and all of that. But if they want to come down to, Business 341s are the exception. But if you just tell them to call us, and we will pre-register them as well. But if not, we are handling that, and we haven't had any issues. And we know it's a little bit of an inconvenience, but it's unfortunate. It's just the world that we live in today. But if anybody has any questions about any of that, you can see me or all of my staff attorneys are here, and we can answer any of those questions.
Thank you. Okay. I think I mentioned at the beginning, a recording of this meeting as well as the PowerPoint we've been discussing will be on the website, I'm going to say by Monday at the latest. And any other questions before we say goodbye? Anything, Lee, on there? Nope. Okay, thank you for coming, and have a great Thanksgiving. Appreciate it.